solutions as they come. From what we heard today, you know, our primary interest in this area is when we have catastrophic failures that injure people. We run into that in a number of situations, and when we do that, we want to make sure that liability is allocated fairly. We want to make sure that that parties that are responsible do not get immunity, and that they are responsible for the damages that they cause, because when they're not responsible for the damages they cause, we all pay the price. That's our primary concern, but we have a number of members that also represent people in all phases of these types of litigation, from the GCs to the architects to the builders, and all phases. One of the things that I found that's interesting about the 1907 case, the Supreme Court recognized something, that a general contractor is in a much better position to evaluate the plans typically than your typical owner is.
Right.
So what the Supreme Court said was essentially, we're going to make the GC responsible. Now the GC can contract around that with a sophisticated owner if they want to, but we're going to make them responsible because they're in a better position to evaluate that. What I fear can occur based on what we heard from the general contractors earlier, is a progressive deprofessionalization of that group. In other words, a GC should be more than just a scheduler. They're supposed to be the professionals, and in many cases they hire most of the subs. They might not hire all the subs, but in many cases they hire most of these subs. They ought to be responsible for hiring good people and for making sure that those folks do good work, because what they produce not only affects the parties to that contract, it affects all Texans that go into those shops and those facilities for perhaps the next 100 years. So we want to make sure that our GCs are doing their duty, and that they do have a significant duty to make sure that their product is a good product.
I agree with that. I mean, and I think most reasonable contractors also agree that when they're responsible, they need to pay up. I think it's the question where the scenario where a reasonably experienced contractor cannot determine if there's a defect in a plan, a hidden defect. You know, we make different kinds of exceptions for the kinds of defects, you know, latent and other kinds. And I assume you would agree they should not be held to the standard of an engineer or an architect. They should be held to a standard that is within their industrial experience, their construction experience, because not all general contractors are going to be as sophisticated as others.
Well, you bring up an interesting point. Since we don't license general contractors, we have a huge varied experience level, but we still need to be able to have a good end product. And if that general contractor is not experienced enough to evaluate those plans, to know if that architect has done good work or that engineer has done good work, then they need to contract around it and say that I'm not going to be responsible for your architect, and they can do that now, and that's completely appropriate. But if they don't do that now, what they are doing essentially is impliedly saying, I've looked at these plans, and I think they can be built. You know, it can be built in a good and workmanlike manner, and it's not going to fail. It's not going to kill Texas.
What about the situation where they disclose it? And since we have determined now that the AIA provision is not in every contract, and is not necessarily even routine, perhaps, should they still be responsible?
That becomes an issue between the parties and the freedom of the right to contract. I mean, if they're going to say...
I'm talking about going before a jury. You know,
I understand.
Let's put aside the freedom to contract, because I think that's a significant issue. But I've seen litigation where the contractor didn't do a single thing wrong.
Mm-hmm.
The architect and the engineer made the mistakes, made a bad design. You know, I guess, where do we start allocating real risk and real liability if you tell people, look, if you want me to build it this way, I will, but I think you got some serious problems, and let me tell you what they are.
Mr. Chairman, in our society, that's traditionally been the function of the jury to allocate fault between the parties, and the jury has the ability to do that. They have the ability to do that now. And if I understand that you do, you know, that you practice law and you do some defense and you've seen some of these cases. You know, I've lost cases that I thought the jury did the wrong thing on too, and sometimes they do and sometimes they don't. But you know, it's the best system that we can have, because statutorily we run risk of never knowing what all the facts are going to be. So statutorily, anytime we have these really extensive statutes to try to deal with issues that juries are honestly more willing and better equipped to deal with, we run into problems because we don't anticipate all of the potential factors.
Okay. Go ahead.
Okay. Well, I just, again, if you have any other questions, I'll be happy to answer them. But like I said, we want to be a resource going forward. But we think that the way that it currently is, with the parties having the ability to contract, that's probably the fairest way we can do it, with the jury able to then look at the situation and apportion fault the way they need to apportion fault.
Would you all also be opposed to some sort of affirmative defense?
We don't think an affirmative defense is necessary right now, but I'd be willing to look at anything.
Okay.
And see what you have and evaluate it. And you know, if there is currently a problem, and you assert there's a problem, I haven't seen the data to support that we're getting a lot more construction cases than we've had in the past. Today's Wall Street Journal came out with an article that says that you know, tort filings of all types have gone down considerably in the last 15 or 20 years. I mean, you know, 80-90%. So I'm not sure that what the antecedent experience necessarily matches with the number of filings and that sort of thing. I'd be interested to see that data.
Okay, thank you. Laura?
Good afternoon, Chairman Oliveira and committee members. I'm Laura Tamez on behalf of Texas Trial Lawyers Association, and really what I could add, because I work in a lot of this, mostly with torts, is the issue of a predetermination of the allocation of liability would be dangerous, in the sense that all of these cases, even in the event of the general contractor being blamed for architectural design, these cases are so fact specific. And in terms of, even with our tort liability cases, the general contractor's liability is commensurate with the control that they exercise over the job. So if the general contractor decides to inspect what the design or the specs and can take corrective action, well, you know, that's something that, again, is fact specific. It creates a fact issue. If the GC doesn't do any of that, and there's no evidence of any control over design, and this is assuming that can't get past a no evidence summary judgment, right, which is a remedy, either on a cross-claim or contribution or indemnity issues, all of that aside, there still has to be that, it's almost the affirmative defense is already there in terms of our liability is commensurate with the control that's asserted over the project. And so that's one issue. I think the other issue is, because there, you know, a construction site or even oil and gas is so fluid and dynamic, and let's say there's change orders or modifications or whatever the case may be, again, you're going to go back to the control that's asserted. And I understand when there's a GC who does nothing, and all the remedies of, a cross-claim and everything else doesn't get them anywhere but before a jury. And there's an issue of should there be a jury instruction or should there be something like that? As long as it's not, a comment on the weight of the evidence or gives the jury the idea that, the law is X, that a contractor is immune
Right. No,
for, certain issues.
I wouldn't want to see any
Right.
general immunity.
Right.
Frankly, there's always going to be, it's going to be a cake mix situation. I get that. It's just these cases where I've seen contractors with, $500,000. They have to pay the first $500,000 of defense costs and fees, and then at the end, even though it was very clear from all the way. I mean, motions for summary judgments are a rarity. They're like a triceratops, in my opinion, particularly in South Texas. But that may be just our problem. But I'm encouraged to hear that you all might consider a possible jury instruction or something. That I'm just looking for maybe some new approaches, new ideas. So I appreciate you at least being willing to consider that.
Well, and really, it would take some more research.
Certainly.
To
I
consider.
can't even think of one right now, and as
Right.
soon as I think of it, I don't like it.
Right. Well,
It's not going to be easy.
No. And the 1907 case, I'm not convinced that that's the law of the land, based on a couple of cases that I'm thinking about, which I can provide to the committee members.
I would love to see those. Really would.
Because, and obviously, the worst case scenario would be to shift the responsibility of having a homeowner or a business owner who's contracted with professionals to design a building to be warranting the sufficiency of specs and plans.
I think I
bad.
agree too with the testimony that residential needs to be different than
Right.
commercial. And we'd have to look at it in a different way. So I agree with you on that. Representative Collins?
Thank you, Mr. Chairman. Laura, the first thing you said stuck with me. You said a predetermination of allocation of liability would be dangerous. And I completely agree with that now that I understand everything that's going on, because you remember the case where the guy was on his balcony, and this is for commercial, because the guy's on his balcony, they're partying on the balcony, and then it collapses.
Right.
Okay, so when we're talking about liability there, the person who was hurt, they don't know who designed it. They don't know who was maintaining it, who, followed through the plan. So if you're going to have show who's responsible, you have to go and try to track down everybody who was involved. And then that's where you get into I know you have to pay out of pocket. I don't know what it's called. It's like your deductible or something.
Deductible.
Yeah, your deductible. And unfortunately, you have to pay your deductible until you can prove that, or until you can show that you're not responsible in that. And I understand that you can contract your way out of it by doing an indemnity clause in your contract. But until then, the injured party doesn't know that, and they have to, continue. Any attorney, I would have to be zealous against everybody that had a hand in it, because I wouldn't be doing my client any justice if I didn't do that. And so I think that if we're going to talk about determining, we still have to keep the jury or the judge, whoever you go in front of, involved, because it is case by case. And it may be something that the design was right, but when they implemented the design, it was wrong. And so then the designer gets off, but then the contractor.
Right.
So I think that's where but why would we do something different for commercial?
The main reason, I think, as she said and others have told me, is the sophistication of, us drawing up, even as lawyers, designing our own home or telling somebody how we want it done versus, somebody from the Chemical Council, their members, or Texoga's members. There is a sophistication between those parties that isn't going to exist between an owner, in a residential situation. And it doesn't mean there shouldn't be something done in that area.
Okay.
It's just, the problem I've seen, at least my experience, has been in dramatically in commercial cases.
Where they're getting
and
sued?
government buildings and things like that, yeah.
So you're thinking of maybe an indemnity clause or some type of
No, I mean,
immunity?
I'm open. I just think, I mean, the freedom to contract issue colors all of this too. At the same time, I firmly believe there's an injustice here to some contract. In fact, in the Valley, what we found, and in South Texas in general, architects and engineers were going naked without any insurance. So the contractor was always the target.
Oh.
Because frankly, they couldn't afford liability insurance because of all the lawsuits. And so many architects and engineers, and I'm not saying it's that way all over the state, but that made it real clear who the target had to be.
Oh.
Yeah.
Okay.
But that's a separate issue, I guess. All right. Any other questions, members? I want to thank everybody for coming today and participating. We appreciate it very much. And I'd say have a happy special session, but I don't think that's going to happen for most of us.
Yeah.
So thank you all very much.